Hello friends, welcome to Edushine Law. In this video, we are going to discuss about section 113A of Indian Evidence Act. This deals with presumption as to abatement of suicide by married women, and we are going to discuss it with a recent judgment from Supreme Court. So let's start. So section 113 of A, what does it say? When the question is whether the commission of suicide by a woman had been abated by her husband. So the issue is the abatement of suicide. Abatement of suicide. Then by her husband or any relative or of her husband, and it is shown that she had committed suicide within a period of 7 years from the date of her marriage, and that her husband or such relative of her husband had subjected her to cruelty. The court may presume, having regard to all other circumstances of the case, that such suicide had been abated by her husband or by such relative of her husband. तो यहाँ पे देखिए, यहाँ पे क्या इशू क्या है? इशू है कि द एबेटमेंट ऑफ द सुसाइड ऑफ द मैरिड वोमेन. ठीक है, तो यहाँ पे कंडीशन ये है कि शी हैज़ टू कमिट द सुसाइड हैज़ टू बी कमिटेड विद इन द पीरियड ऑफ 7 ईयर्स. 7 साल के अंदर, शादी हो के 7 साल के अंदर ये सुसाइड अगर कमिट करती है और ये प्रूव हो जाता है कि शी हैज़ बीन सब्जेक्टेड टू क्रुएल्टी, देन द कोर्ट प्रिज्यूम कर सकता है कि एबेटमेंट ऑफ सुसाइड हुआ है. ठीक है, एक्सप्लेनेशन यहाँ पे है, द क्रुएल्टी जो वर्ड यूज किया गया शैल हैव द सेम मीनिंग एज इन सेक्शन 498A ऑफ आईपीसी. ठीक है, देखिए जो रिसेंट जजमेंट की बात यहाँ पे किया गया है, दैट इज राजू भिकाभाई चौहान वर्सेस स्टेट ऑफ गुजरात. And in this judgment, the Supreme Court has explained the applicability of Section 113A of Indian Evidence Act. So, according to Supreme Court, and according to this section, there are these 3 conditions. The first condition is that this one is the first condition. The woman has to commit suicide. The woman has to commit suicide. Second condition is that such suicide has been committed within a period of 7 years from the date of her marriage. And the third condition is that the charged accused had subjected her to cruelty. तो अगर ये 3 एलिमेंट प्रूफ हो गया है, if these 3 element has been proved, then the court may presume that the abatement of suicide is proved. Now this is subjected to rebuttal. तो दैट मीन्स कि अब एक्यूज के पास या डिफेंस के पास ये चांसेस है कि वो ये डिस्प्रूव करे कि द एबेटमेंट ऑफ सुसाइड वाज नॉट देयर. ठीक है, ये सेक्शन सिर्फ ये कहता है कि अगर सुसाइड होता है तो एबेटमेंट ऑफ सुसाइड अलग से प्रूफ करने की जरूरत नहीं है प्रोसिक्यूशन को. उनको बस सिर्फ ये 3 एलिमेंट प्रूफ करने की जरूरत है. अगर ये 3 एलिमेंट प्रूफ कर देता है, द कोर्ट शैल ऑटोमेटिकली प्रिज्यूम दैट द एबेटमेंट ऑफ सुसाइड इज देयर. Now it is up to the defense to prove that the abatement of suicide is not there. ठीक है, so ये जो केस के बारे में यहाँ पे कहा गया उसके फैक्ट्स क्या है? द प्रोसिक्यूशन केस अगेंस्ट द एक्यूज्ड. ठीक है, द प्रोसिक्यूशन ने ये कहा, प्रोसिक्यूशन केस क्या था कि द वाइफ कमिटेड सुसाइड बाय कंज्यूमिंग पॉइजन. ठीक है, तो द फर्स्ट एलिमेंट इज प्रूव्ड. The suicide was committed in her matrimonial home, not being able to bear the continuous mental and physical cruelty. So the third element is proved, and this happened with short span of 8 months of the marriage. So here the second element is also proved. Hence the 3 element is already present in this case. So the presumption under section 113A, under section 13A of Evidence Act is automatically arisen. तो हुआ ये कि the trial court convicted the accused under section 498A and 306 of IPC is about abatement of suicide. ठीक है, and the High Court upheld the conviction. Now this was challenged before the Supreme Court. ठीक है, now the defense counsel had raised a contention. The contention of the defense counsel was that all the prosecution witnesses were relative of the woman and interested witness. So based on their testimony, this cannot be proved. So in this regard, the Supreme Court gave the explanation that there is no legal bar of the relative and interested witness testimony. There has to be close scrutiny, but once that test is passed, such witness can be considered reliable. ठीक है, तो जो विटनेस होता है, जो अगर इंटरेस्टेड विटनेस है और अगर रिलेटिव है, उसके ऊपर क्लोज स्क्रूटिनी होना चाहिए, क्योंकि उसमें एक बायसनेस आने की चांसेस है. बट इफ दे आर truthful and trustworthy, if the test of the close scrutiny is passed, then their testimony can be considered a perfectly reliable witness. Second second argument is that, explanation is that, it is not unusual in domestic matter that independent witness is absent, as it generally takes place in the confine of four walls. ठीक है, and third is, even if the independent witnesses are present, they seldom come forward to become witness due to various factors. बहुत बार ऐसा होता है कि इंडिपेंडेंस होते हुए भी वो आगे नहीं आता है, विटनेस बनना नहीं चाहता है, उसके लिए बहुत सारे फैक्टर्स इन्वॉल्व होते हैं. Fourth is, the woman generally confides the torture she is going through in her relatives. That is the usual course of incident, and hence in the instant case the witness testimony were held to be properly reliable and admissible. Now with regard to the presumption, Supreme Court ने ये explanation दिया, once the three elements have been proved, the presumption of abetment of suicide arises. तो इस केस में क्या है, वो एलिमेंट 1, 2 and 3 तीनों एलिमेंट प्रूव हो चुका था. ठीक है, सो ऑटोमेटिकली द कोर्ट कैन प्रिज्यूम the abetment of suicide. Now the burden of proof is on the defense to rebut such presumption. ठीक है, and if the rebuttal cannot be done, the presumption is established and becomes conclusive proof. तो इस केस में जो डिफेंस है उसने डिस्प्रूव नहीं कर पाया, उसने रिबट नहीं कर पाया, and hence the conviction is proved, and hence the conviction by the trial court and its upholding by the High Court was correct in law. ठीक है, so that is the explanation in this judgment by the Supreme Court given towards section 113A of Indian Evidence Act. Now Indian Evidence Act is a procedural law. It is a procedural law, and it is only upon the proof of that incident, right? So that is all for this video. Thank you.